Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineer. Alright, good day to all the viewers, to all the students, and to anybody else who's out there who might bump into this YouTube account, Legally Engineer. And as a matter of review, from the last discussions that we had in the video lectures posted in this YouTube account, we've discussed articles 1163 to 1166 of the new civil code, still under the topic of the nature and effect of obligations. Now we go to article 1167 and let's see what the codal provision provides. Let's read in article 1167. It says here, if a person obliged to do something fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. So, it's important for us na tingnan ano ba yung mga situations contemplated under Article 1167. Now, it refers to an obligation to do. So, it's a personal obligation. Remember, if it's an obligation to do, it's a personal obligation. More specifically, it's a positive personal obligation because it's requiring the debtor to do something. And, for example, to perform an act or to render a service. And it contemplates three situations. If we're going to look at the codal provision, the first paragraph, it's actually contemplating a situation wherein the debtor fails to perform an obligation to do. So, pag yung debtor natin, hindi niya nagawa or hindi siya nakagampan sa obligasyon na meron siya, yun yung kino-contemplate sa first paragraph of Article 1167. And then, notice that there is a second paragraph, and the second paragraph of Article 1167, it contemplates two situations. The first of which is when the debtor performs an obligation to do but contrary to the terms thereof. So yung kanina, yung debtor na meron tayo, he absolutely fails to perform the obligation to do. As in, wala talaga siyang nagawa, no? Samantalang yung pangalawa, ito naman, nag-perform yung debtor, may ginawa siya. However, yung ginawa niya ay contrary to the terms or dun sa conditions na napag-usapan nila. So in short, meron siyang pagkukulang, meron siyang ginawa, pero yung kanyang ginawa ay hindi naaayon sa napag-usapan. So that's the second situation contemplated under Article 1167. And the second half of the second paragraph of the same article contemplates the situation wherein the debtor performs an obligation to do but in a poor manner. So ngayon naman, nag-perform nga yung debtor na meron tayo ng obligation niya. However, it was poorly done. And so, in this case, the question that we have in mind is, pag ito yung nangyari, ito ang ginawa ng debtor, hindi siya nag-perform ng obligation, o kaya nag-perform siya pero contrary naman sa napag-usapan, o kaya nag-perform siya pero it was poorly done. Ano ngayon ang remedies ng creditor in this positive personal obligation? Yung magandang topic na pag-usapan natin dito. And so, puntahan na natin, ano ba yung mga remedies? Una, if the debtor fails to comply with his obligation to do, the creditor has the right to two things. First, the creditor has the right to have the obligation performed by himself or by another unless personal considerations are involved at the debtor's expense. So, himayin natin yun, no? So, ang una daw na remedy ng creditor kapag ang debtor natin ay hindi nag-comply or hindi nag-perform dun sa obligation to do niya, ang una daw is, pwedeng ang gawin ni creditor, siya na lang ang gumawa, no? Gawin na lang niya by himself kung ano yung supposedly dapat gampanan ng debtor. At kung gagawin niya on his own, yung expenses na ma-incur niya by performing the obligation which was supposed to be done by the debtor, then it should be at the debtor's expense. So kung magkano man yung magastos ko, si debtor ang magbabayad noon. Or, kasi may mga personal obligations to do kasi na merong consideration, no, yung qualification ng certain person. Halimbawa, an obligation to do for example, to perform a song, no? So definitely meron kang pinipili na artist na choice mo talaga para siya yung kumanta. And halimbawa ako, gusto ko sa upcoming wedding ko, for example, is pakantahin ko halimbawa si Moira de la Torre kasi gusto ko yung boses niya, yung kanta niya. Kung halimbawa, hindi makagampan si Moira de la Torre, well, I cannot do the song on my own on her behalf kasi nga ibang usapan yun kaya siya yung napili ko kasi meron siyang merong personal consideration kung bakit siya, so I cannot do it on my own. So those are instances wherein there are personal considerations involved. But in any case, kung halimbawa nga ako na lang yung mag-perform ng obligation or ipagawa ko sa iba, ang magagastos doon should be shouldered by the debtor himself. Okay? So that's the first remedy. And of course, the second is to recover damages. Sa second contemplated circumstance naman under Article 1167, in the event that the debtor actually performed the obligation but it's in contravention of the tenets thereof or the same is poorly done, then it may be ordered by the court that it be undone if it's still possible to undo what has been done. So, nandito na yung principle na what has been poorly done should be undone. Of course, at the expense of the debtor himself. It should be the court that shall order that what is poorly done should be undone if it's still possible. Kasi may situations naman talaga na hindi na posible na ma-undo pa what has been done. So, in that case, as a creditor, then you just recover damages for what you suffered. Alright? Under Article 1167, if you'll notice it, there is a remedy on the part of the creditor to actually let the obligation be performed or be done by a third person, no? Pero kung manonotice nyo, under 1165, meron dong option ang creditor to actually compel the debtor to deliver what has been promised, for example, because under 1165 it's a real obligation to deliver. So pwede doon, no, na ma-compel ang debtor na mag-deliver nung kung ano yung dapat i-deliver. And notice that the same remedy is not available under Article 1167 kasi walang nakalagay dyan that the creditor may actually compel the debtor to do what has to be done. So why is that so? And we will discuss that now kung bakit hindi available ang specific performance in an obligation to do. You know, a personal obligation to do, like a real obligation to deliver a generic thing, can be performed by a third person. Well, the debtor can be compelled to make the delivery of a specific thing under Article 1165. A specific performance cannot be ordered in a personal obligation to do. Why? Because this may amount to involuntary servitude. Uulitin ko. In a personal obligation to do, a specific performance cannot be ordered because that may be tantamount to an involuntary servitude which, as a rule, is prohibited under our Constitution. Article 3, Section 18, Paragraph 2 of the 1987 Constitution. So, tatandaan nyo yun, guys. Okay? Sa personal obligation to do, bawal ang specific performance because that is contrary to what the Constitution provides. And alam naman natin that the law that we have, di ba, under sa introduction to law natin, it cannot be contrary to what the Constitution provides. And any law that would be against to what the Constitution provides shall be declared null and void. And the same shall be abandoned or abolished. That's the reason why under 1167, walang nakalagay dyan na pwede ang specific performance or pwedeng i-compel ng creditor ang debtor in the event that the debtor fails to perform his obligation or personal obligation to do. Tatandaan na, magkaiba ang remedy when it comes to personal obligation to do at ang remedy kapag real obligation, such as an obligation to deliver. However, pag meron ng personal qualification, kasi nabanggit ngayon sa 1167, di ba? Kasi tayo naman kapag mag-hire tayo ng services ng, for example, ibang tao to perform an obligation para sa atin, meron tayong pinipili no? Merong personal qualifications, kaya pinipili natin yung tao na yun. So, sinasabi ng batas, the personal qualifications of the debtor are the determining motive for the obligation contracted. Kapag ganun ang nangyari, for example, to sing sa birthday party or to sing sa wedding, in that case, alam natin na ang personal qualification ng debtor is the determining motive for the obligation that's contracted. In that case, the performance of the same by another would be impossible or would result to be so different that the obligation cannot be considered performed. So, sinabi ko nga kanina, kung halimbawa si Moira de la Torre ang kinuha ko sa kasal, tapos at the day of the wedding, hindi makapunta si Moira or hindi siya makakanta, kung halimbawa ang kakanta na lang, for example, ay ako, at the day of my wedding, in that case, hindi lapat. Do medyo marunong naman tayong kumanta, pero kung titingnan mo, hindi talaga lapat, no? So it's as if hindi na rin na-perform yung obligation, yung personal obligation ni Moira de la Torre. So because it would be so different, the result would be so different. Can you imagine kung halimbawa kakantahin ko yung mga kanta niya? Hindi kasi yung boses ni Moira very distinct yun So it's as if the obligation is not performed kahit na nag-substitute ako ng iba. Hence, in that case, the only feasible remedy of the creditor is indemnification for damages. So, naalala naman natin yan, no? Kung ano yung mga obligations ng debtor. Kapag hindi na available na ipagawa sa iba, ang available remedy na lang talaga ng creditor natin doon is ma-indemnify siya for damages that he or she suffered. Now, where the obligation can still be performed at the expense of the debtor, notwithstanding his failure or refusal to do so, the court is not authorized to merely grant damages to the creditor. So, kasi kapag naman nga daw yung obligation, pwede pa namang ma-perform at the expense of the debtor, even if there is failure or refusal for him to do so, hindi agad-agad ang court ay nag-grant ng damages to the creditor, no? Kasi kung pwede pa namang ipagawa nga sa iba, pwedeng ipagawa naman sa iba yun. Alright? So, take note of that. So, for example, under Article 1167, halimbawa, no, sa news, I think, in social media, medyo kumalat tong itong news scoop na to when it was found out that Jinky actually she contemplated, or I don't know if she bought an Hermes bicycle, no, and sumabog talaga sa social media. So for example, Hermes, I hope I pronounce it right, Hermes binds himself to assemble a vintage bicycle for Jinky, and it was stipulated that the bicycle shall be painted all gold. So si Jinky, kinomission niya sa Hermes na, hey, you make a vintage bicycle for me, and I want it to be painted all gold. Alright. So si Hermes nag-oblige, so there is an agreement between the two of them. Now, if for example guys, Hermes failed to assemble the bicycle, kung nag-fail, hindi niya na-assemble yung bicycle, vintage bicycle painted all gold for Jinky Pacquiao, kung hindi yung nagawa ng Hermes, then Jinky may ask, for example, Agot, Jinky may ask Agot to assemble one at the expense of Hermes. So dito pumapasok ang sinasabi sa 1167, kung hindi nagawa ng original debtor na hindi siya nag-comply sa performance of his or her obligation to do, in this case to create the vintage Hermes bicycle for Jinky, then Jinky may hire a third person, in this example Agot, to do it for her. So if Agot would be able to do a vintage Hermes bicycle for Jinky, then in that case si Hermes should pay or shoulder the cost incurred in commissioning Agot to do it for Jinky. So naintindihan? So in that case, again, kapag nag-fail si debtor to perform the obligation, the creditor may hire or commission another to do it for her, and all the expenses shall be shouldered by the original debtor. What if naman guys, suppose si Hermes, inassemble naman niya nga yung bicycle. However, it was painted, let's say, all white. So, salip na gold, white ang kanyang color. So, anong mangyayari? In this situation, si Jinky, she may ask to have it done according to the specification. So, dito na yung tinatawag natin na, yes, there was a performance, but it's in contravention to the tenor or to the agreement to what has been stipulated between the parties. Ano ba yung stipulation? Ang stipulation nila is that the vintage bicycle should be painted all gold. There was a painting here and it was painted all white. So kung makikita nyo, yung contravention or yung paglabag na ginawa ng Hermes dun sa kasunduan nila na dapat gold, ay white ang ginawa niya. So in that case, Jinky may ask to have it done according to the specification. Pwede niyang ipagawa yon kay Hermes na dapat i-paint mo yan ng gold. However, Jinky cannot compel kasi kung hindi gugustuhin ng Hermes na ulitin yun or repaint yun, she cannot be compelled, right? Because that would be tantamount to involuntary servitude. So, hindi pwedeng tutukan ng barel si Hermes para, oy, gawin mo yung bicycle na yan, i-paint mo yan ng gold para sa akin dahil yan yung ating original na usapan. Nope. Jinky cannot do that. So, what Jinky shall do if Hermes refuses is that the obligation may be performed by a third person, for example, in this case, by Agot, at the expense of Hermes. So, kung ayaw na Hermes na pinturahan ng gold according to the original tenor or the original stipulation between the parties, then no problem. Jinky would just hire another third person, in this case, Agot, so that Agot would paint it gold for Jinky, while Hermes shall pay the expense incurred by Jinky for commissioning Agot to paint the bicycle gold for her. Intindihan? Okay. So, yun yung first two instances dito. However, for example naman, si Hermes, inassemble niya nga. Hermes did assemble the bicycle and painted it with gold. So, tama naman nga eh. It was painted with gold, but it was poorly done. Halimbawa, may bubbles or pumuputok-putok yung pinturang gold dun sa bicycle, or sabihin natin may mga rough edges yung bicycle, or basta yun nga, hindi maganda yung pagkagawa nung bicycle. In that case, dyan na yung papasok yung the debtor performed the obligation but it was poorly done, no? So in that case, Jinky may ask Hermes that it should be undone, no? Ipaulit kay Hermes yung pagpipintura para maging pulido yung finish nung bicycle. But again, Jinky may not compel Hermes to do it for her. And in the event that Hermes would actually refuse to undo it, then si Jinky, she may again commission another third person, in this case Agot, to paint it at the expense of Hermes. Okay? So, in no case can Hermes be compelled against his will to comply with his obligation should he refuse to do so. Okay? So, bawal ang pilitan. Pagdating sa Article 1167, tatandaan ninyo yun, bawal ang pilitan under Article 1167. Kung ayaw mo, di huwag, but I would let other people do it for me at your own expense. Okay? So, ganun ang sistema under 1167. Ito pa, example, kasi nga, binabanggit naman kanina na merong sa personal obligation to do, yung personal qualification ng tao, nung debtor, yung consideration. For example, if Regine Velasquez, for example, she binds herself to sing the national anthem in a fight between Manny Pacquiao and another boxer, no? I've heard Manny Pacquiao is contemplating of having another match. So if, for example, Regine was commissioned to sing for that much awaited and anticipated match, and Regine fails to comply with her obligation, so ano mangyayari? Well, the performance of the same by another would be impossible or would result to be so different that the obligation could not be considered performed. Why? Kasi personal qualification ni Regine kung bakit siya ang na-hire. Alam naman natin kung gaano kagaling siyang pumirit, kung gaano kagaling siyang kumanta. And for example, kung isa-substitute halimbawa sa kanya si Kim Chiu as a singer, kung halimbawa si Kim Chiu yung ipapalit mo kay Regine to sing for that boxing match, we know that it's as if hindi ma-comply yung obligation. Parang impossible, or it would result to be so different. Ibang-iba yung resulta noon kumpara kung si Regine ang kumanta noon. So, in that case, the obligation could not be considered performed. Hence, the personal qualification of Regine in this example is the determining motive for the contract. Kasi kung hindi naman dahil sa galing niyang kumanta, hindi naman talaga siya yung mako-commission. So it's as if parang it's too personal that commissioning another person or a third person to do it for the creditor would be somehow equivalent to failure to perform the same obligation. And in this case, anong remedy ng creditor natin? Only practical remedy here of the organization na nag-hire kay Regine for that match is indemnification for damages. Kasi nga, personal qualification ni Regine yung determining motive for the contract. Question, pwede bang i-compel si Regine to sing in that match on the day that the much anticipated boxing match is about to start? The answer, no. Regine cannot be compelled as a debtor to sing in that match because again, it's a positive personal obligation, and compelling Regine to sing would be tantamount to an involuntary servitude, which is contrary to what the Constitution provides. Okay, so take note of that. Alright, so ituloy-tuloy na natin kung Article 1167 talks about a positive personal obligation. Pag pumunta ka sa 1168, it talks about a negative personal obligation. Bakit ka mo? Kasi Article 1168 provides that when the obligation consists in not doing and the obliger does what has been forbidden him, it shall also be undone at his expense. So somehow may common dito na remedy, no, ang creditor na meron tayo. So bakit ba natin nasabi that this is a negative personal obligation? Una, kasi entrada pala ng Article 1168, sinasabi na doon that the obligation consists in not doing. And take note that if the obligation is not to do, that is a personal obligation, and negative because the obligation is in not doing what is forbidden. Okay. So, ano yung remedies ulit ni creditor in negative personal obligation? Well, in an obligation not to do, the duty of the obliger is to abstain from an act. So, alam naman natin yan. Ang obligation niya dyan is, huwag mong gawin kung ano yung pino-forbid, kung ano yung pino-prohibit. Here, there is no specific performance. Obviously, no? Kung sa positive personal obligation, wala ring specific performance, wala, with much reason, walang specific performance in a negative personal obligation because the very obligation is fulfilled in not doing what is forbidden. Diba? So, it doesn't make sense na i-compel mo to specifically perform yung tao, ang performance nga ng obligation is in not doing what is forbidden, no? So, yun yung very obligation So, wala talaga ditong specific performance. Hence, in this kind of obligation, the debtor cannot be guilty of delay. Ayan, may pumasok na delay. Pwede discuss yan under Article 1169. Kasi, ang naman, kapag ang obligation mo is a negative personal obligation, it cannot be said that the debtor is guilty of delay. Kasi, when will you say that he is guilty of delay? Ang obligation niya nga is not to do what is forbidden, no? So, not to act, wala kang gagawin. Huwag mo dapat gawin. So, as a rule, the remedy of the obligee in this case, or the creditor, is the undoing of the forbidden thing plus damages. So, yung remedy dito ni obliger, ni creditor, halimbawa, si debtor, pinagbabawalan siya na gawin yon or hindi mo dapat gawin yan, pero ginawa pa rin niya. So, hindi nga siya pwedeng specifically i-compel or para i-perform yung obligation kasi nga, do not do nga eh. So, ang gagawin dyan ni creditor is that ipa-undo yung forbidden thing. Kung ano yung nagawa, i-undo yun. Okay? Plus, of course, damages. However, if it's not possible to undo what has been done or what was done, either physically or legally, or kaya naman, meron ng third person na pumasok and the third person acted in good faith and now he has acquired rights over it. O kaya naman for some other reason, no? Ang remedy ngayon dito ng obligee creditor is an action for damages na lang caused by the debtor's violation of his obligation. So kapag negative personal obligation, una, tingnan mo muna, pwede bang i-undo? If it can be undone, edi let the forbidden thing that is done be undone plus damages, no? Na pwedeng singilin mo from the debtor. Now, if it cannot be undone anymore, what has been done or yung forbidden thing na nagawa ay hindi na pwedeng i-undo, then the only possible remedy there is an action for damages. for the debtor's violation, again, of his obligation. So, let's give an example in this negative personal obligation at ang remedy ng creditor. Ito, common na common to sa mga adjoining lots, no? Yung magkakatabing lupa na nagkakaroon ng bentahan, and mostly yung mga lupa na meron tayo, there is ang only access natin sa barangay road or kaya sa national road ay minsan dadaan tayo sa lupa ng iba, no? Kung halimbawa nabenta sa iyo na lupa ay nandun sa likod at merong fronting lot na nasa harap mo na kailangan dumaan ka doon para maka-access ka nga doon sa road. For example, normally kapag yan nagkakaroon ng blockage or nagkakaroon ng fence, nagkakaroon talaga ng legal dispute between the adjoining owners of these lots. So for example, may lupa si seller nandun sa harap na malapit sa kalsada, and then yung binenta niya na lupa kay buyer ay lot na nasa likod ng lupa na meron siya. So si buyer naman niya, okay, bibilhin ko yung lupa na binibenta mo sa akin provided na wag kang magtatayo ng fence. Kasi pag nagtayo ka ng fence, syempre mawawalan ako ng access sa kalsada. So, that has been agreed upon. Okay, so kaya binili kasi meron namang agreement nga, stipulation na hindi ka pwedeng mag-construct ng fence diyan. So, ano ang obligation dyan? Syempre, ang may obligation ngayon dyan is yung original seller. Anong obligation niya? Bawal magtayo ng fence. So, not to do. So, personal negative obligation. Kasi not to do, not to construct a fence, not to do what is forbidden. However, guys, what if si seller, after the lot was bought by the buyer, seller constructed a fence, and the same, of course, is in violation of the agreement? Ano na ngayon ang magiging remedy ni buyer na nawalan ngayon ng access sa road? Of course, malinaw ang sinasabi ng Article 1168 that the buyer can have the fence removed at the expense of the seller S plus payment for damages. So, alright, so take note yung correlation ng Articles 1167 and 1168 kung paano in both instances when there is failure to perform on the part of the debtor, whether it be a personal positive obligation or a negative personal obligation. So we know that in both instances, sabi doon, what is poorly undone should be undone. Or pagdating naman dun sa negative personal obligation, if it can still be undone, then let the debtor have it undone plus payment for damages. And of course, yung undoing nun is at the expense of the debtor who violated his obligation or who did not comply with the obligation incumbent upon him. Alright? So, yes.